And they had the whole training facility and everything for the police academy. It was pretty interesting. They gave us a tour.
You always have the nerves when you walk in this building, so many oral arguments, I always have a little bit of, and they always say a little bit of anxiousness.
We're the friendly JNC. Good morning, Judge.
Please, the James.
Yeah.
Just had the pleasure of meeting you again, Mike Sasso. What we're going to do is each of the commissioners will introduce themselves. We have one commissioner who's appearing by phone, Commissioner Amanda Perry Carl. And she may or may not ask questions. After we do the introductions, you'll have much time as you need, but typically a couple, 3 minutes to make a little opening statement about yourself. And then there will be question and answer. And about 23, 24 minutes in, I'll kind of interrupt the Q&A and let you make a final statement.
Thank you.
Mike, I have a question.
Yes.
I have Amanda's questions.
Okay, great.
Good morning. Vincent Citro from Law Offices of Fort Winston Citro.
I'm sorry, Craig Dyer, Stephen Sergeant, Public Defender's Office.
Andy Bardos with Gray Robinson.
And Mike Sasso and Commissioner Amanda Perry Carl is on the
Good
speakerphone.
morning, Ms. Carr.
Brett Renton with Schutz and Bowen in Orlando.
Good morning, Petra Brownlee with the Brownlee Law Firm.
David DeArmas at Kramer Price and DeArmas in Orlando.
Morning, Your Honor. Scott Thomas with Burr Foreman Law Firm.
Thank you for, again, your hard work. As a former commissioner on the 7th Circuit JNC, I know the time and dedication, and I felt very rewarding experience was to sit on the JNC. I was always proud of the being part of the interviews and also the candidates that we put forth to the governor. So I appreciate and are mindful of the time it takes to do what you do, and I'm thankful for it. I thought about what I would say in my introduction, and it's really two things. I could reread my resume or my application, but you're all familiar with my experience and kind of how it built to the point that I am now with a position on the circuit court that I'm honored and blessed to have. The two things I wanted to talk about in my brief opening were, and as appellate lawyers, I think that that some of you that practice appellate will understand that I didn't think to put in my application, but in December of 2006, I had the unique experience of back-to-back oral arguments on a Tuesday at the Florida Supreme Court, and then turning around, driving back and arguing a state appeal here at the 5th DCA. I look back and think, how did I do it? I had a 1-year-old, but I did it, and argued a successfully Reeves versus State in the Florida Supreme Court, which was a sentencing issue on the criminal punishment code serving consecutive to a mandatory sentence under the prison release reoffender statute, and then also a tangential issue on criminal episodes and how we could sentence. And then I turn around and come back and argue totally different as an appellant, arguing a order granting a motion to suppress and trying to overcome some factual findings on a non-custodial, custodial interrogation conducted by Orange County Sheriff's Office detectives. Not so successful on the state appeal in all candor. They're always an uphill battle. You're battling with factual findings. So it's a unique experience that I had, and I look back on it very fondly, happy to have the opportunity to obviously argue in front of the Florida Supreme Court, which I was able to do several times, but then turning around and regrouping, and took a quite active panel. I believe it was Judge Thompson, Judge Sawaya, and Judge Palmer had a good time with me on the state appeal. And the PCA came back shortly thereafter. But unique, not something I put in my application, but it kind of tells you what I used to do. 16 years in appellate practice, starting as a law clerk, continuing with my service at the Attorney General's office, and then obviously bleeding into my civil practice with the County Attorney's office. In each position, while it's public service, it's also service in the public eye. Understanding as a law clerk that the work we did for our judge was a reflection on him. Obviously representing the state of Florida, I'm arguing on behalf of the state, wanting to make solid legal arguments, mindful of constitutional rights and all the things that we need to do. And then locally as a county attorney, really in the public eye in terms of sitting on boards as the legal counsel for code enforcement and all the boards that I sat on as their legal advisor, but also being available to members of Volusia County Council who would drop by our office at any time and say, look, I've got this question from someone in the public. Can we do this? So you're always sort of under this public eye, and it's something I'm very proud of. It takes a lot of gut constitution sometimes when you're questioned, but at the same time, and obviously now as a judge, that is probably ultimately where you're under that public scrutiny of public service. But I'm very proud of it, that's been my career. And it's something I obviously would love to continue to do as an appellate judge. I feel like it's kind of the written work product and the legal research and the ability to understand the importance of, especially as a circuit judge now doing that appellate work, I understand your findings of fact have to be supported by the evidence. They have to be applied, the laws to be applied correctly. And those are certainly skills I learned for a long time in appellate practice and have put forth in my written work product, in final judgments, orders on motions, and obviously in the written work product I did for the county. So that's sort of the short end. The double OA was always something I kind of look back on and chuckle to myself about, hoping you're not getting a flat. The last time I had oral argument at the Florida Supreme Court, I did get a flat on I-10. So you never know, but like thankfully I didn't have to come back and argue somewhere else the next day. It just took for a longer ride home. So.
Okay, so I'm gonna pull up Ms. Perry Carl's, I didn't want to fiddle with my phone while you were talking, so just one sec, okay. So she vetted you, but so I'm just going to read it exactly the way that she wrote it. Okay. It looks like you appeared in front of the 5th District Court of Appeals somewhat regularly while you were working as an Assistant State Attorney General. Is there a case that you argued in front of the 5th that stands out to you as a memorable case? And if so, why does that case stand out?
In my significant cases is the Barber appeal.
Mm-hmm.
That case got a tremendous amount of media attention because it was an older case, it was on 48 hours. All that aside, what was meaningful to me about that case is the relationship that I developed with April Barber's aunt. She was actually a judge in the state of Oklahoma, and she flew here and watched the argument with her husband. She raised the victim in that case. So I can talk about, we had great legal arguments in that I argued against Mr. Kent, who's an experienced appellate attorney. He came up with a novel judgment of acquittal argument. So I take that, obviously, legal activity and challenge, but also the relationship I developed with Judge Parrish was very meaningful to me. And I remember when the opinion came out affirming the conviction and being able to call her and tell her we have had justice for April. So that relationship actually continued when I was appointed to the bench. She dropped me a note and congratulated me. And so you walk away with those kind of relationships. And I could talk about, and the state appeals I've lost stand out in my mind. I'll never forget Justice Lawson saying, well, that's no different than asking for a glass of water, when he was saying that he wrote it, the invoke the right to counsel. I remember certain times thinking, no, that's not. But so the state appeals were always challenging because those were the ones where we would not be successful. But I know that the thought was that ask for oral argument in your state appeals. Get up there and make the argument and show the Fifth that we're serious about what this is, knowing that you have factual findings normally that really aren't in your favor. So obviously the case of Justin Barber was hugely significant to me, and I've explained it in my application, but I just wanted to give you a little bit more in terms of that relationship that I was fortunate to have with Judge Parrish. She's now retired.
Thank you. Can you provide a case that you have read lately that was particularly well-reasoned, and why do you think that it was well-reasoned?
There's two, but I'll talk about Justice Lawson wrote an opinion in December of last year, straightforward, short, on the standard ground law and immunity. What was telling me about that was the conciseness with which he approached statutory construction, how you do it, and when you need to go out and look at other statutes. And I think that sometimes that's lost when we want to construe statutes and we'll read this in parliamentary with this, but you don't do that initially. And I thought that that opinion, while short and concise, really kind of is a great way to look at how you should analyze a statutory construction issue. Obviously, well, not obviously, the other case that stands out is the June case of United States versus Gamble out of U.S. Supreme Court, where Justice Alito wrote about stare decisis, but Justice Thomas wrote a very lengthy concurring opinion on stare decisis and its historical versus and the length of it. And it's really kind of one of those concurring opinions that you really need to read several times, but had impactful in terms of his analysis. So those would be the two cases of recent memory that stand out in my mind.
Do you agree more with the majority on that case or with the concurrence by Justice Thomas?
You know, I've been thinking about that, and I knew that would prompt that question. And that's one of those things where I do think that Justice Thomas's notion that it's demonstrably erroneous would be the time that you break away from stare decisis. I think we can all learn from that standard and understand the value of stare decisis, obviously, is how we keep things in order and prevent chaos, but how he addressed when you divert from that, and if it's demonstrably erroneous under the Constitution. I've thought about it. I do agree with it. I can't say 100% if I jump on, cite that in terms of, but, because obviously Justice Alito's majority opinion is rules the day. But it's something I've really been thinking about and kind of reading some articles about and kind of digesting it since it's relatively recent.
Sure, it is. Okay, and I think that Ms. Perry Carl has one more for you.
Okay.
I see from your application that you have presided over the National Adoption Day proceedings on multiple occasions in Daytona. Can you tell us a little bit about what that involves and what that experience is like? And then what is the most rewarding part of the day?
The National Adoption Day is really, it's cases that I've presided over in DeLand. So it culminates in adoption. So some of the children were there that were sheltered in front of me, and their dependency case progressed into a termination from rights, and then we have National Adoption Day. It's a celebratory day, but the nice part of it is you get to meet other families and watch other judges close the chapter for these children and families. It's just truly an honor. I mean, and to sit there and be able to introduce everyone the first year I did it, kind of as a new judge, was really quite flattering. But it's just that finality and the happiness that you know that these children have finally permanency, finality in a loving home. So the best part really actually is going out. Usually it's California, it's a little north of us on the ocean. We go out on the patio and take pictures with the ocean in the background with the family. That's really the best time because you can really kind of enjoy the moment with them and get to know their the people that are with them. But it's truly, it's so wonderful. Any adoption and dependency is meaningful and quite special. And you'll have adoptions where maybe a 12-year-old who's been with a permanent guardian a long time, and it's a small ceremony. And then I think a couple weeks ago I walked in and there was 40 people with balloons. So,
Wow.
but each one is special in its own way. And I try to make it meaningful for the family, but really it's about these parents and their amazing dedication to these young children.
Thank you. I think that's all from her.
Okay, thank you.
I'm curious, this is your first application to us?
Correct.
And so we've had a couple openings in the last several years, and I'm curious why now?
That's a good question, and I anticipated it as well. Certainly when I was first appointed, I wanted to spend time on the circuit bench. I think that there's value in that. So, and I've been on now, I'll be at 3.5, almost 4 years. The most recent ones, quite frankly, my son was getting ready to graduate from the Air Force Academy. I wanted to kind of see where we were in my family. It wasn't the right time familial. Now it is. He's moved on. He's in his first year of law school. It's been really enjoyable. He called about his torts professor last night about the reasonably prudent person, so it brings you back. I still won't be able to answer what the rule in Shelley's case is if he asks me, but it's coming. It's coming. I know it's coming. I'm going to have to Google it or something. But I think it just instinctively in my career, I've had to follow my instincts in terms of taking that leap from the AG to the county. And quite frankly, I felt this was a great time for me to be challenged by you as a commission and to do it. And the other really part of that, my answer has to be, I did have the opportunity to sit last June with Judge Berger and Judge Torpy, and come over here as a judge was quite, Judge Palmer asked me to sit in for him while he was had other engagements, and that was really kind of where I started to think, this is where what I love. Dialogue with the law clerks on citation, and one of the Blue Book rules had changed. You know, like things like that, and it brought back really what I feel my strengths are. But ultimately, it was a timing issue. Instinctively, I was ready to face y'all now.
In that experience of sitting, what shocked you the most that was just unanticipated that you learned from that experience?
Nothing shocked me outright. Getting used to an electronic record, that's showing my age a little bit. That was different and an adjustment. Really, that just being on that podium and asking a question of a litigant and getting an answer back that I didn't expect. Not shocking, but, oh, I might not have answered it that way, so let me think about that answer and kind of take the time to digest rather than pepper. I think that I learned from that, and I was expecting to be, I surprised myself in that regard, that I really needed to listen to some of these answers. And when you're an appellant and an appellee, listen to the question, well, it's certainly important to listen to the answer as well. So I wouldn't call it shocking, but definitely something I've learned from. But I thoroughly enjoyed it. When I walked out there, though, I remember the nerves of those two attorneys sitting on either table. I always try to be respectful of that.
Your Honor, unless it's something that can't be disclosed, what's the process by which you sit by designation? Do you make it known as a sitting judge you're interested in that? Does the DCA chief judge just reach out to you? Because there doesn't seem to be a lot of consistency that I can tell between the number of years on a circuit bench and the opportunity to sit by designation.
Judge Palmer called and asked,
Okay.
and I jumped at the chance. I had seen Judge Orfinger at an event and certainly had said, look, if you ever need anybody to pinch it, I'd be more than willing to do that. And then he called. He obviously needs to be coordinated through the Supreme Court and the Chief Judge. But he called, and I was more than willing to step up to the plate. Sometimes I use baseball analogies, but love to step up to, my baseball player son, but softball too. I was a catcher, yeah, until I tore my ACL. So yeah, that's how it was for me. I was thrilled, and it was he called, I sat in June. I think he called well in advance so we could make sure, out of respect for my calendar and coverage, but that's how it was for me. I can't speak for anyone else. It was great.
I'd like to ask you about one of the cases that you discuss in your application. And you talked about statutory interpretation. This is the Rollerson case.
Oh, that's an old one.
From
Yeah.
2000, yes. So it's a bit dated, but you say in your application that you argued to the Supreme Court that the word conviction in the statute includes adjudications withheld because it's consistent with the overall scheme of the statute and legislative intent to impose harsher penalties. Could you talk about the statutory interpretation argument in that case and why the court was right to adopt it?
Well, we looked at the statute and what it was, obviously it's each penalty, with each offense, the degree of crime increases. So ultimately it became what the legislature intended by using the word conviction. Did they want it to just be adjudications or did they include adjudications withheld? So that was sort of the premise that we started with. Tangentially, I need to note, I got pinch hit for that for OA. So when it was in the fifth, I wasn't on the case. I came in at the end, so I had to learn it. And it was a little hard because you're giving the judge, by whether they construe it as a conviction or not, that was the separation of powers argument, that by giving the judge the discretion to withhold or not, whether that impacted whether the degree of crime would be severe. So that was really the constitutional argument that we said, no, you gotta find first that the adjudication isn't conviction, and then it eradicates the judge kind of impeding on the legislature. So that's really the argument that we made, and it was both of those, that constitutional challenge, dovetailing in what that word means in the statute. Obviously, we looked at other statutes use of the word conviction and whether it was inclusive to adjudications withheld. And that was the process that we went through to make that argument. But it was quite a while ago, and again, it was a lot of cases from all over the state that were heard together. I think there were 4 or 5 of them, and I would be tasked with that. Corey Franklin was another case that came from South Florida that was transferred up to our office for us to handle in Daytona. The Daytona office, and Mr. Dyer can attest to, they had a great, and I hope still do, imagine still, a great working relationship with the Appellate Public Defender's Office. It was very collegial. And our office, my former office across the bridge there, would often be tasked with taking cases from other offices to argument the Supreme Court. And I was always very honored when that would, those boxes would land in my desk, in federal court as well. But that, Rollerson, Franklin, those were statewide cases that I was blessed to be able to argue.
I was just about to ask you about Franklin. So that looks like a single subject case. Could you tell us what was the argument in that case, which side you were on, and what the outcome of the case was?
The argument in that case was that the legislature kind of log rolled in two sections. One was on pleas. They added some additional language on involuntary plea, and then they log rolled on certain terms and rolled them into this overall sentencing scheme. There were two sections, it's probably in my, two sections of the overall bill that they felt the that was the constitutional challenge, and we argued successfully to the Supreme Court that in its entirety the act was related to sentencing, and the use of, I think it was the use of a statutory term to enhance was a part of sentencing, and as well as how they addressed that other section. It was all, but so we had to argue against log rolling to find it constitutional, and we were successful in that regard. That one was pretty daunting to go up there. There's a lot of lawyers, and you're trying to divide your time, and you know those kinds of things are just kind of behind the scenes. You've got to work out if there's 2 or 3 lawyers for the state, how much time you want to divide, and make sure you don't talk too much so they get their time. So, but that was to argue that every section related to it was an act. The act was related to sentencing was the title or in the preamble, and we had to argue that those sections certainly put forth that purpose as well.
I've asked a lot of questions of other folks about PCAs. I'd like to get your views on them.
Well, I didn't like it in that state appeal. Understanding the PCA, the per curiam firm, has its place. I think I'm happy that the rule was amended to allow for an attorney to move to say, hey, you PCA, can you give me a little bit of citation? The strength is better. I think a citation PCA provides more guidance to the litigants, and the litigants have to be answerable to their clients. So to the extent, for me, I understand the efficiency of PCAs. I clerked on the Indiana Court of Appeals where there were no PCAs. It was either a published or an unpublished opinion. So I remember when I first started at the AG's office having a conversation with someone in your office about that, like, what is this? You know, because we had to write on everything. And it was short and concise, but you still were able to afford the parties some rationale as to how you reached your conclusion. In the overall scheme of things, in my practice in 14 years, sure, I love to get a PCA, but at the same time, I understand even that a short citation to authority to say this is what really carried the day, I think is more helpful to a litigant. But there are some cases where a PCA is the most efficient and appropriate. There's nothing new or novel. It could be a very short, you know, I filed my 3850 within 2 years when it was 4 years later. You know, things like that I think are ripe still for a PCA opinion. Never liked them in my state appeals, and I certainly got them. So I know it's like to be on the receiving end of it, but certainly the one where I argued it, I knew exactly why, because the court made their case very clear to me. So, but in the short answer is yes, but limited.
When you took the bench in 2016, did you have any role in getting assigned to the family law court? Is that was a choice, or is it random assignment? Or
Judge Perkins was the chief judge at the time, and when Judge Blackburn and I were appointed, it was going to be either her family division. It was one of the two. I requested the unified family division. And I'll be quite honest with you, I had never seen a shelter hearing until my first one on the bench. So for me, it was learning an entirely new area of law and something I wanted to do, something, and again, I'd say instinctive, that's where my instincts led me. And no regrets with that. So Judge Blackburn took over the family law, and we worked very closely together because I do related family law cases on anything that comes out of it all. Unified family stems with the dependency case, but family law issues arise. So we work very closely together. But ultimately, it was Judge Perkins' decision. But my request was to take unified family. Trust your gut.
have you had the opportunity to move to a different division since 2016?
I have not, but I am moving to family in City Island in about a month. But I always made sure and I've sat in all 4 counties. I've done some civil trials. I did drug court recently this summer. Done felony, criminal, obviously with your first appearance, but I covered up in Putnam County when coverage was needed. Covered in Flagler County, and then covered a fair amount of family when Judge Miles became ill and we had to cover that docket, so I did docket sound and case management. And so I've always tried to pinch hit when my schedule allows. Our dependency docket is busy, and I'm in court pretty much every day. But when I have the chance of something, a trial didn't go, I always volunteer to do something different. And I've sat in St. John's quite a bit in their dependency docket, and then I did some civil, and I did drug court for Judge Christine, which was really great. I enjoyed it. I love the problem-solving courts. I'm very proud of our early childhood court on the west side. We've had tremendous positive results with parents of young children, and I was happy to get it up and running, and we're really enjoying it. So I'm hoping to keep that once I move back to this side of the county, which the flip side is I'm looking forward to coming back to Daytona since I worked here. I left in 2010. So.
You ever get over to Putnam County?
I did. I covered on Judge Wolf's docket. I did a couple criminal pre-trials and dockets when I was up there with him. And remember, they left they continued a sex offender sentencing violation of probation, and I walked right into it, and the prosecutor, the public defender, asked to approach and said, "Tag, you're it. We want to get this. We're ready to sentence today." So I got thrown on something unexpected, but I was really actually impressed with the lawyers that were in front of me up in Putnam. Not that but just I had never been there before as a judge, so I did cover a few times.
Yeah, but it's the only circuit with 4 counties, so it was.
Yeah, Putnam, yes, yeah. So I've I've been all 4 as a circuit judge.
If you had to say, we all have mentors, but as far as in the judiciary, if you had to say you had a mentor, who would it be and why?
My mentor will appellate-wise, it was actually Judge Sawaya was a great mentor to me. In his kindness, in his thoughtfulness, he was somebody that I talked to when I applied to the circuit bench. And I just always appreciated his sort of straightforward delivery, but in a kind way. And I never felt uncomfortable around him outside of the courtroom. He made me feel very comfortable. As a mentor judge, and I answered this question in front of the 7th, it was Judge Rouse, always. As I appeared in front of him when he was on the civil bench, I appeared in front of him when he visited here. And so he has always been and continues to be a mentor to me. He is someone, if I can email or call, if I have a question or if I'm struggling with something, he is my go-to person still, and I appreciate that. I mean, even as a retired judge, I saw him at Circuit Conference last month, and we took some time to chat and catch up, and how are things going, what can you do, and I will always be respectful of how he was as a judge, how bright he was, that twinkle in his eye he'd get when I knew he was going to hit me with some zingers. But always I learned so much from him, watching him, not only when I'm waiting to be for my motion hearings or things like that, and how he handled pro se litigants, but then when we tried some cases in front of him. But he'll remain my mentor, and I'm blessed. I told him I'm blessed he fell into my life. But I remember when I met him for the first time, I think it was in coffee over here, the 5th. He was sitting the 5th. So it's a long history with Judge Rouse.
Anybody else have any questions? Thank you, Judge. That concludes the Q&A portion.
Okay.
And I'd like to give you an opportunity to say anything in closing.
I just reiterate my thanks to you all for the hard work that you do and that form of public service. I look at it this way. I'm truly blessed in each job that I've had, and I mentioned that. And when my 22-year-old can say, "You've liked every job," I have. I really have. But I truly am honored and blessed to do what I do every day on our circuit bench. And I look forward at some point in the future doing appellate work. It's really where my heart has remained and lied. So again, I feel very blessed to sit here. Thank you for interviewing me. I'm with obviously incredible candidates. So I wish you good luck, and it's a tough job you have, and I've been there. But ultimately, I'm mindful of the time and effort. So with that, I thank you.
Thanks for coming.
Thank you so much.
It's nice to meet you all. Thank you.
Me too.
Very nice to meet you.